Hi everyone, and welcome to Greenway, either online or in person, for the next in our series of super series of presentations conducted every year in March and February. Tonight, Ajay, Sivanathan and I are going to deal with some of the recent but lesser known developments in strata security of payment and design and Building Practitioners Act law. So we're lucky enough to have been in a few of these cases that we want to share some of the war stories with you. So Ajay is going to deal with some of the strata issues, and then I'm going to deal with some of the security of payment and Design and Building Practitioner Act decisions. So I'm going to hand over the floor to Ajay, but before I do that, Ajay joined us at Greenway in 2023 after stints at Ashurst and as a tip staff in the Supreme Court. I've worked with Ajay over the last couple of years, and during that time I've done my best to extol the virtues of construction law into him, and I think I'm slowly succeeding. Outside of the law, I'm told he contributes to the bar soccer team and is a big movie fan, but likes to curl up on Friday night with a good CLR, so he likes to get stuck into all the case law with you. So without further ado, I'll leave it to him.
Thanks, Declan. The thing I should caveat is that this first case I'm going to talk about is a matter that Declan and I ran together for 2 weeks in the Supreme Court last year, and that is the case of Owners Corporation and Elkhouri and Owners Corporation SP 6534 and Perpetual. What's interesting about this case, if I might take a second to flick the slide. What is really interesting about this case is that it threw up a series of both procedural and substantive law issues that were all ventilated to an extreme degree by all parties, which resulted in a 2-week Supreme Court trial at first instance and then a 2-day appeal in the Court of Appeal. The relevant judge at first instance was Justice Elkhouri, and in the Court of Appeal, the leading judgment was given by His Honour Justice McHugh. What I propose to talk about today is 4 things arising out of the Strata Schemes Management Act. The first is the assessment of whether or not a common property rights bylaw is considered to be unjust. And connected with that is the question of jurisdiction, that is, whether or not the Supreme Court has jurisdiction to determine a matter arising under this piece of legislation in circumstances where it specifically said that it was if the tribunal finds, and I'll take everyone through both of those things subsequently. The next thing connected with that is the question of whether or not the bylaw was actually unjust. And finally, with respect to the strata levies that were imposed by the Owners Corporation, how you can assess, if you can, whether or not a strata levy was reasonable and what kinds of considerations go to the reasonableness or lack thereof of a levy imposed by an Owners Corporation. So to start with, what I'm going to do is talk about the factual background that arose with respect to the Elkhouri case, and it's an interesting one. Justice McHugh described it as a case about harbour views, and for that reason it was litigated for more than 6 years, and before that it had been litigated for 4 or 5 years in the tribunals. It was really about the use of certain common property areas associated with a penthouse in Point Piper. Now, that penthouse traversed 3 levels. It had, and around each of the levels was balconies, as well as a top level, which was seen to be a kind of green space where people could be entertained. Now, the relevant unit, and this is another complicating factor, the original owner died in the midst of the litigation, and so it was conducted thereafter by his executors and sons. And to make things even more complicated, what actually happened was that there was a mortgagee in possession who subsequently became involved in the litigation, and so all 3 parties were now joined in a combined piece of litigation. It all was about the rights to that common property area, which I've spoken about, which was purportedly resolved by way of a deed of settlement in the earlier Supreme Court proceedings. And arising out of that was a bylaw, which was a common property rights bylaw, which and under that bylaw, the deceased was granted certain rights over those common property areas for 1 year, and that was only to continue after that 1 year, being a sunset date, if the deceased had fully satisfied certain preconditions that were defined as critical obligations. And those critical obligations include things like work, insurance, and the payment of certain monies for the impact upon other lot owners in this penthouse building. What happened was that in 2018, the deceased commenced proceedings against the owners, saying effectively that he wanted declarations that he'd satisfied all of the preconditions in the bylaw, and as a result had those continuing rights to their common property areas. Subsequently, the owners filed a cross-claim seeking in effect to recover a series of unpaid strata levies, but also seeking a series of monies under the said bylaw, arising out of things like expenses and costs in terms of building and so on. Now, subsequently, in December 2021, Perpetual, who was the mortgagee in possession, they commenced proceedings against the owners in NCAT. And then this is what creates the jurisdiction problem, because at that point, there was two extant proceedings. One in the Supreme Court of New South Wales, that's between the deceased and the owners corporation, but also there was another proceedings brought by the mortgagee in possession in NCAT. And now what happened was, in an effort to streamline the proceedings, it was all broadly consented to bring both proceedings together in the Supreme Court. And this gives rise to, this gives rise to the first question about jurisdiction. And what you'll see here is the two provisions, which is the Section 149 and Section 139. Now, relevantly, all that matters for our purposes with respect to Section 139 is it says that Section Sub 1 says a bylaw cannot be unjust, and that is, a bylaw must not be harsh, unconscionable, or oppressive. And it says specifically, any such bylaw may be invalidated by the tribunal pursuant to Section 150. And you'll see here that Section 150 talks about the tribunal doing things if the tribunal considers certain things. And now, relevantly for our purposes, it was 149 that was the main provision that was litigated. And this one specifically, the argument made by the owners in the Court of Appeal was that Section 149 empowers only the tribunal to make an order prescribing a change to a bylaw, and moreover, only the tribunal is empowered to make a finding that the precondition for making that order is satisfied. That is to say, whether or not the bylaw itself was unjust, it was argued by the owners that decision, that consideration, could only have been made by the tribunal. That is to say, the Supreme Court couldn't make any finding at all, such that all of these proceedings over 6 and, as I said, 10 years now becomes OTOs, such that it needs to go back to the tribunal to have them re-exercise the discretion, having spent all of this money and all of this court time. And a similar argument was put with respect to 139 and 150 because of the way in which the words tribunal may and if the tribunal considers were characterised, at least on the owner's argument. The Court of Appeal reasoned in a way that might be expected when it comes to a court assessing the limitations of its own jurisdiction. That is, that it won't try and curtail its jurisdiction as much as it possibly can. Justice McHugh said essentially that the owners corporation's basic proposition that where a statute confers power on a tribunal to apply a statutory test, the Supreme Court has no authority to hear or decide questions which involve applying that statutory test unless the statute specifically authorises the court to do so. Justice McHugh said, that stands the proper approach to the court's jurisdiction on its head. In effect, it was that the jurisdiction of the Supreme Court in matters in which you're seeking a declaration is always very wide, and so long as the matter wasn't hypothetical or otherwise lacking in utility, and here it wasn't hypothetical. It was about a real set of rights associated with a real bylaw, which had real impacts upon both the owners as well as the executors, and from a further perspective, from the mortgagee in possession. The court said, well, this type of question and this type of circumstance meets the statutory discretion quite comfortably, and that is, it is clearly within the scope of a court's authority to decide and the power to answer by the discretionary remedy of a declaration. Now, what's very interesting about this situation is that sometimes, by operation of the NCAT Act and schedules to the NCAT Act, when there are two proceedings, one in the Supreme Court and one in the tribunal, where issues or facts that traverse both proceedings are raised, what the operation of the NCAT Act is that it stays stays the second proceeding to start. And so this case managed to circumvent that through a series of interlocutory stages. But what may indeed happen is that a case might be brought in the tribunal about things like strata law or things like a common property rights bylaw, but there might be a similar case arising out of the same facts about defects in the Supreme Court, or as was here, which is that the second part of this case was about defective works allegedly conducted by the deceased over common property. And so now you've got a situation where a similar fact scenario with similar issues are being traversed once in the tribunal and also in the Supreme Court. And the question is, are you caught in a circle where you can't determine the second in time proceeding up until you've actually figured out or finally completed the first one? And then the court said, well, this is the type of situation where if the owners corporation come and tell the Supreme Court that, wait a second, you couldn't, this court can't even determine this question because you say it's only the tribunal. That's a situation that the court wasn't happy with, and the court considered not to be the type of way they would interpret their own jurisdiction, as well as thinking about things like comedy between matters, because there's a possibility, for instance, that the Supreme Court could come to a conclusion about unjustness, and as I'll come to, which was different to that thought by the tribunal. And so if you had a remitter back down to the tribunal, the question is, well, does the tribunal simply adopt everything that the Supreme Court had said with respect to all of the matters that I've talked about before? Or is what the legislation really asking for the tribunal to re-exercise that discretion, re-exercise each of those elements that I'm talking about, if the tribunal may make and if the tribunal considers afresh? And so at that point, what's the point of the first proceedings? And that was kind of the underlying premise of the reasoning of the Court of Appeal here. The connected part of this, and this is the next point that I'm coming to, which is, how do you characterize a bylaw or a strata bylaw? Is it legislative or contractual? And this has real impacts, because the way you interpret a legislative provision is significantly different to a contractual provision. And relevantly in this case, if a bylaw, a common property rights bylaw in a strata corporation was contractual, that has impacts upon, if it's contractual, it has impacts upon assessment of damages. It has impacts upon the importation of contractual principles like remoteness and causation into the damage that may or may not arise. And so it seems, based on the Court of Appeal's reasoning and their adoption of a statement by Her Honour Justice McColl in a case called Owners of Strata Plan number 3397 and Tate, which is reported at 2007-70 NSWLR 344, that you can characterize them either as delegated legislation or statutory contracts, but from an interpretation perspective, the characterization may be a distinction without a substantial difference. There seems to be some indications recently in a recent case called Coleman and the Owners Strata Plan 61131, 2025, New South Wales 63. Justice Kirk said seemed to indicate that there's a possibility that it is truly legislative in character. And so this is the other kind of consideration to think about in circumstances where there are lots and lots of owners' corporations doing building works, which come with assessment of damages and quantum questions. And if it's legislative, well, do we import those contractual principles into the assessment? Now, the next thing I want to talk about now, and I'm coming back to this 149 slide, is the question of unjustness. And in many ways, the predecessor to this case, or the assessment of unjustness, was a case called Cooper, which was about the 13-year-old Schnauzer, where there was an owner's corporation or a strata corporation with a common property bylaw that prohibited the ownership of pets. And that case was run under, relevantly for our purposes, Section 139. And as far as the submissions went in the Court of Appeal in the case of Elkhouri, the argument was that the words harsh, unconscionable, and oppressive were equivalent to unjust by reason of the way in which that piece of legislation is set out. That is, the word unjust is in bold and subsequently in unbold, or in ordinary, it is harsh, unconscionable, and oppressive. And you'll see here that the word unjust arises at Section 149(1)(c), and so the argument between both parties was essentially that there was the same thing. Now, the Court of Appeal disagreed with that, but relevantly, the next kind of related question as to assessing whether or not a common property rights bylaw is unjust at all is how you use this legislation to determine unjustness. And now the Court of Appeal specifically said that subsection 2, which says, in considering whether to make an order, the tribunal must have regard to two factors: the interest of all owners in the use and enjoyment of their rights of their lots in common property, and the rights and reasonable expectations of any owner. Now, those two considerations, the court said, were not the balancing exercise expected with respect to assessing whether or not something was unjust. That these two considerations were something that came afterwards, and the word unjust should be assessed and should be interpreted in accordance with the ordinary use of the word. And so the Court of Appeal criticised the reasoning employed below, which basically said, well, to assess whether something is unjust, we're going to look at these two factors that are just underneath and say, how are the interests of all the owners affected? And secondly, what are the rights and reasonable expectations of any owner deriving and anticipating a benefit? And the Court of Appeal said, in fact, you have to do it twice. You do the unjustness, and then the assessment by the tribunal would be, well, how do these factors affect it? And specifically, that doesn't go to whether or not a declaration that doesn't have any impact upon a declaration about unjustness at all. Now, the next question and the next part of this unjustness assessment of this clause is whether or not this type of common property rights bylaw critique needs to relate to maintenance or upkeep. And because if you see on subsection C of sub 1, it says, on application made by any interested person, that the conditions of a common property rights bylaw relating to the maintenance of or upkeep of any common property are unjust. Now, the argument made by the Owners Corporation was that in order to enliven Section 149(1)(c), the relevant part of the bylaw that you're impugning needs to be with respect to maintenance or upkeep alone, and without that relation, you couldn't use 149(1)(c) at all. The court disagreed with that. The Court of Appeal disagreed with that. And the court below, in the Supreme Court in the first instance, they disagreed with that as well, by reasoning that so long as the bylaw had some parts relating to maintenance upkeep, and this one did, it had things about repairs and works to be done, that the power given by 149 was enlivened, and that wasn't an issue in the end. And so that was an argument that was run twice and lost both times. The next thing to say is that what I've spoken about in terms of the difference between Section 149 and 139, though both parties didn't really disagree, the court reasoned that, in fact, the question asked by 149 was something that was much broader than, as to unjustness, was something much broader than what's asked by 139. And the reason His Honour Justice McHugh said that is because 139, in His Honour's view, only allowed one to consider matters inherent to the bylaw. That is, you had to interpret it really like a contract or a piece of legislation that was confined, and that you couldn't have reference to the extrinsic circumstances that came into the entry into this bylaw. Now, the reasoning from the Court of Appeal essentially was that no, you could give some credence to both sides of things, which is the inherent matters and as well as the extrinsic matters. But here, His Honour essentially said it didn't matter, but relevantly, what he said about the inherent matters is that there was a limited nature and scope of a grant of the grant of common property bylaw rights under the bylaw, and that there is nothing intrinsically unjust about granting a right, being here extension of certain rights of exclusive access to common property only upon the satisfaction of certain reasonable conditions, and that there would be nothing intrinsically unjust about granting a right on the basis that it may be terminated in the event that certain conditions are not satisfied. But in any event, with respect to the second element, which is what were the extrinsic matters relating to the bylaw and what was the context under which it was entered, the Court of Appeal agreed with the Owners Corporation to say, well, this was an overall commercial bargain in which there was a quid pro quo, there was a chance for the deceased to obtain very, very valuable rights, which the court agreed was in the order of some $2.25 million. That is, to sell a property without balconies had a delta of $2.25 million. And so that essentially was a huge part of the quantum element of the analysis, and that it involved real compromises, and that it stopped extant litigation in the Supreme Court because it all arose out of a settlement deed, and the court shouldn't go ahead and try and rework or re-enter what was a commercial bargain between two parties who were relatively sophisticated, and they both had lawyers at the time, and that given that it all was a part of a deed, there was benefits to the deceased in that if he managed to do certain works at his cost, he could get the benefit of those $2.25 million of rights in terms of the balconies, and that the consideration was, well, he's going to do the obligations, the extant works, the works that were causing certain water ingress into lots below, and that was the deal, and that was a fair deal, and that shouldn't go, and the court shouldn't go back and try and rewrite that deal. And that essentially was the final position taken by the court, in that having a common property rights bylaw cease, or having common property rights cease on not completing certain conditions, having a year to do it, including an assessment at the relevant time, that it was only going to take 6 months, and you can have 6 months in lieu for weather and other extenuating circumstances. The court said that was a perfectly fine deal, and that you can't come in here and try and say that it was unfair just because we missed it. And that was in the face of certain specific arguments saying, well, what happens if the deceased went ahead and finished all of the conditions a day after the year finished? Would that not be characterized as a penalty? And that argument, relying on penalty principles, was also rejected by the Court of Appeal, because it was the type of thing where two sophisticated commercial parties essentially came into an agreement where they'd already built into it an account for risk, an account for the kind of circumstances that might result in the deceased finishing everything on time, but also not finishing everything on time. And the trade-away was, well, now the Owners Corporation will have to do the works on the common property areas because it's their responsibility now to do it. And so that kind of analysis was what seemed to inform what the Court of Appeal said in opposition to what was said at first instance. This leads me to another interesting element of this case, which is that the idea of what is a reasonable amount, or how to assess a reasonable amount of strata levies. And now this is pretty important because strata levies are raised quite a lot, and there has been, interestingly, there had been only one case ever that had determined that had said how you determine reasonableness of strata levies if a challenge was brought, and that was a case called Cleggett and OC of the Strata Plan 35541 2013 in the New South Wales CTT 359. And so having only one case in the CTT determining this was an interesting turn of events, because in terms of the factual background of the argument brought on this case, which is that the mortgagee in possession essentially said the levies that had been imposed by the owners' corporation on all of the lots were excessive or unreasonable. And they said it was this on two bases, and they split up the two levies that were unpaid. The first one was, they said, you've raised $120,000 or $128,000 to be exact to pursue legal action against Lot 11 itself. And so what you're asking us to do is to pay monies by way of strata levies in order to fund a legal attack on my own lot. And so the reasoning was, that was a pretty unfair way for the owners' corporation to ask Lot 11, which is the subject lot, to pay a proportion based on its strata entitlements to the owners' corporations to bring a claim against it. And so this wasn't disturbed on appeal. His Honour Justice Elkhouri said, with respect to the legal costs at least, it's unreasonable for an owners' corporation to levy levy monies for the purposes of paying lawyers generally, and that if you were to do so, you would have to exclude Lot 11, or an obligation on Lot 11 to contribute in its share to the payment of those strata levies. The second part, which is another interesting factual element, which is that there was an amount of $100,000 to install a stairway to a rooftop area which was connected with Lot 11's area, or with Lot 11's, or was connected to some of the levels of Lot 11. The argument put, interestingly, by the mortgagee in possession was that work had never been done. It still hadn't been done, and it seemed to be caught in some sort of council hang up in that there hadn't been approval essentially as to what kind of stairway would be put in, whether or not it was internal or external, and or who, if anyone, was ever going to do it. And the argument was, that $100,000 should be considered to be excessive or unreasonable, given that it had been at the time a couple of years and nothing had been done. But what His Honour Justice Elkhouri said was, no, the position should be different with respect to the staircase, and that even if the staircase would not proceed, or the building of the staircase would not proceed, all that would happen is that there'd be a credit to the lot owners, and they'd get the money back. And at any such later meeting, they would say, you can come back and give me that proportion of the money, or you can use it as a credit on some other subsequent strata levies that needed to be paid. Now, that's why that one was an interesting one, because you can see circumstances in which certain lots would be unhappy with the size of special levies that had been levied upon them for things that may not actually come to fruition, but also in this context, if there is a dispute internally between the lot owners, how could one lot owner who's the subject of the dispute be expected to pay for the legal attack on them? That's my selection of the interesting elements of this case. There were some other more anodyne defects type reasoning and issues which I haven't dealt with. But as I said, if you look at the front page on these, you might see some familiar names. And I'll hand it over to Declan for the next part.
Thanks, Ajay. All right, so we're now going to turn to security of payment, which I know everyone's going to find riveting on a Tuesday afternoon. In particular, the one particular issue stood out in the last year is there's been more movement than there has been in the 25 years before that, and it hasn't got much attention because everyone seems to be focused on the real high-level cases, but it's these issues about statutory debt claims. So claims under Section 15 when there's no payment schedule and people rock up to court to try to enforce the debt. Section 15 of the Act says that you're in those circumstances where there's no payment schedule, you're entitled to judgment for the unpaid portion of the claimed amount. Now, somehow in the last 25, going on 26 years, the Security Payment Act has been around. There's been no judicial analysis as to what that means. So, in particular, just to back up, I assume everyone's got a passing familiarity with security of payment. So Section 13.1, you can submit your payment claim. Section 14, you can put on a payment schedule in response. You've got 10 days to do that. If you don't put on a payment schedule within 10 days of the time required by the contract, 14.4 says that you become liable to pay the claimed amount to the claimant on the due date for the progress payments. Section 15's got the consequences. 15.1a, the section applies if you become liable under 14.4, and B, fails to pay the whole or any part of the claimed amount on or before the due date of the progress payment to which the claim relates. And then in 15.2a, you've got the two options: either go to court to recover the debt or make an adjudication application after giving them another opportunity to put on a payment schedule. So, what we had at the end of last year is a series of cases between Kennedy Civil and Lynx. It started in the local court, and it was just very traditional, didn't put on a payment schedule, they wanted judgment. It was a really big case. They got judgment for $15,000. But plaintiff was unhappy. They didn't want 15, they wanted 50. So they appealed, and appeals from the local court, turns out, go to the Common Law Division of the Supreme Court under, I think it's Section 39 of the Local Court Act, for those playing at home. That provision only entitled appeals on questions of law. You can't appeal on question of fact. So most of the case was trying to, I wouldn't say dress up, but try to characterise the alleged error made by the magistrate as an error of law rather than an error of fact. And so the real issue was about this $30,000 of payment that hadn't been made from the head contractor to the subcontractor, but had been made from the head contractor to a third-party supplier. And the argument was that the payment to the third-party supplier discharged the liability to pay the subcontractor. And the magistrate accepted that at first instance, but on appeal, that was one of the arguments that was sought to be agitated. And it was framed in two ways. So the first argument was that it was asserted that reliance on the $30,000 payment to reduce the claimed amount amounted to a cross-claim, and as a result, it was prohibited from being raised under the restriction in 15.4b. That argument wasn't accepted. Essentially, the court, which is Justice Wright, noted that Lynx did not seek any cross-claim. There was no independent or additional claim for relief against Kennedy. The second argument that Kennedy tried was that was just as a matter of statutory construction, whether the $30,000 must be taken into account to determine the unpaid portion of the claimed amount. The court's, Justice Wright's decision was in essence that it was a factual matter, and then because this was an appeal limited to question of law, they were locked out. They couldn't raise it. But in any event, went on to say that even if they could raise it, because there was valid evidence before the magistrate at first instance, that was enough. You wouldn't get up on an appeal of fact. So, at the end of that decision, there's an interesting comment that's recorded to say that it was accepted during oral submissions that reliance on a payment to reduce an unpaid portion did not amount to raising any defence in relation to matters arising under the construction contract. So despite that result, Kennedy was not dissuaded, and so they thought, we might have been unsuccessful once, but let's have another crack at it. And so they went off to the Court of Appeal trying to get that $30,000. Justice Baston wrote one of the main judgments. His Honour His Honour opened by stating that this was an important issue. The question of whether, to what extent you can take into account payments where there's no payment schedule is an issue that can affect potentially a whole lot of people. And so it was important. However, ultimately the court decided that they weren't going to grant leave. They thought it was an inappropriate vehicle for three reasons. First of all, unsurprising, the amount. Usually you've got a threshold of about $100,000 you need to be above in order for leave to be granted. Here, $30,000, you're well below that. Secondly, because there'd already been one level of appeal, he'd already gone to the Supreme Court, why should there be a second ground of appeal? And the third was that because the way in which the case had been run at first instance, there was a lot of agreement between the parties, so there wasn't a full discussion and argument on all the facts and the law of the surrounding circumstances. So for those three reasons, they found that their leave shouldn't be given. Just in a passing comment, His Honour Justice Baston threw in another interesting thing, and that is he pointed out that under 15.1b, the requirement is the failure to pay the whole or any part of the claimed amount on or before the due date for payment. And he obviously had his calendar out, and he's worked out that the payments, the $30,000 that was made to the third party, was actually made after the due date for payment of the payment claim. So he seemed to be suggesting that, if this argument had been raised at first instance, the magistrate should not have taken into account those payments, and Kennedy should have been entitled to their judgment of $45,000 or $50,000. So that leads us nicely into the next case, and that is of High Nash Constructions and BRP Industries. And so this is one that Ajay and I were involved in. This started life in the District Court late last year, and I got involved about a week before it was listed for summary judgment. The defence had been filed by a previous set of solicitors and admitted that we hadn't served a payment schedule and that liability had arisen under Section 14.4, but nevertheless argued that a payment that had been made much earlier reduced the unpaid portion of the claimed amount. So notwithstanding that a payment schedule hadn't been put on, that they weren't entitled to the face value of the payment claim because an earlier payment had reduced that liability. So the factual background to that one is pretty unusual. The contract required the head contractor, my client, to make a payment to the subcontractor at the beginning of the project of 10% of the contract sum. So, and this was described as a upfront 10% establishment fee, and the contract price was about $1 million, so the $100,000 was paid right at the beginning of the job. Somewhat unhelpfully, the contract did not have any wording in it, any express wording in it as to how that money was to be applied. Was it security to be held as similar to retention funds and only to be released at the end of the project? Was it to be drawn down on month to month? If so, how? Nevertheless, the contract did have a clause that said if the contract was terminated, my client was entitled to reimbursement of any overpayment. Again, overpayment not defined, just a vague reference. Now, there was a long delay between the advance payment and where we get to the actual payment claim that was the subject of the proceedings. It was about a year later. And that payment claim, I think it was the third payment claim that had been issued on the job, and it was issued shortly after, as in a matter of minutes after the contract was terminated. So it was going to be the last payment claim on the job. It had a face value of about $250,000. But curiously, it included a notation that a certain amount of the advance payment had been drawn down and that $88,000 plus GST of the advance payment was left. That is, the subcontractor was still holding that $88,000 plus GST. So the fight before the District Court under summary judgment was whether there was a tribal issue that the that they weren't entitled to judgment for the $250,000, the face value of the claim, that they were only entitled to judgment of the $250,000 less the $88,000 plus GST. So there was really two arguments. The subcontractor had two arguments against this proposition. The first, they said that because of the set-off provision in the contract, our ability to claim the overpayment, that what I was really raising was a contractual set-off, and that was barred by 15.4 B2. I responded to this by accepting that, yes, if I'd framed it as a contractual set-off defence, it would most certainly be barred. But what we're talking about here is by reference to unpaid portion of the claimed amount, Parliament's own words, that they required the court to consider how much, if any, of the claimed amount had been paid. So that gave the court licence to consider this issue. The second argument was that they said, the subcontractor, that correctly construed Section 15 only required the court to take into account made since the payment claim was issued. And the basis for that argument was that because 15.1b refers to the claimed amount. Now, claimed amount is defined in Section 13 to be the amount set out in the payment claim. So the argument is that before there's a payment claim, there could be no claimed amount. So as a result, by implication, 15.1b only requires you to take into account payments made after the payment claim is issued and before the due date for payment. The district court judge who heard it ignored that argument and just focused on the first argument, and he found that it was a matter arising under the contract, and as a result, entered summary judgment. So my client was unhappy with that, and they appealed, and Ajay joined us for the fun in the Court of Appeal. The subcontractor, presumably somewhat worried that the court might not uphold the district court judge's findings, filed a notice of contention arguing that the decision should be upheld on their backup argument, that is that there's a temporal restriction as to 15.1b, the payments that are to be taken into account, and that they seem to think that was their stronger argument. Given the appeal was worth slightly more than $100,000, it was somewhat surprising that we ended up in the Banco Court before the Chief Justice a few months later, which is the court that most people remember from their admissions. So we drew Chief Justice Bell, Associate Justice Baston, and Justice Adamson, and it's fair to say from the first question that they were pretty clear views on these issues. And the two key findings that they had from this case were how, if at all, the upfront payment was to be apportioned to reduce the claimed amount was a question of construction of the contract, and as a result, it was barred by 15.4. And then I think the second point is possibly more important. They found that correctly construed, Section 15 did not require the court to consider payments made prior to the payment claim. So that is, they accepted that the 15.1b, the reference to the claimed amount, meant that you only count payments after the payment claim. So I think Justice Baston said the reference to the unpaid portion of the claimed amount is a reference to the amount which the respondent to the claim has failed to pay, being the precondition to the engagement of 15.2 as set out in 15.1b. A payment which is not made by reference to that liability because it predated the making of the payment claim does not qualify as a payment of part of the claimed amount. And they said to accept the contrary position would undermine the purpose of the Act. So I think at first instance it might be suggested that this case might not have that much impact because there's not a huge amount of construction cases, particularly in a commercial context, that would require an advance payment being made down the chain. Obviously an exception for that would be the residential works, where it's pretty normal for a deposit to be made. But as we argued, there's one particular scenario where it could come up regularly. And the scenario that we put to the court was that you've got to consider a situation where you're starting a project, it's the first month, contractor performs $100,000 worth of work, they put in a payment claim for $100,000, builder's busy, he doesn't put on a payment schedule, but says, yeah, fair cop, subcontractor's done that work, so they just pay the $100,000. We then come to month 2, and the subby has done another $100,000 worth of work. When they put in the payment claim, they say the cumulative value of the work performed is $200,000. We want $200,000, but whether by oversight or malevolently, they don't take into account, they don't acknowledge that $100,000 payments has been made. They just say $200,000, don't make any payment. Sorry, no payment's been made. If the builder then only proceeded to pay the $100,000, the extra amount, the subcontractor could still, based on the Court of Appeal's findings, get judgment under 15 for the other $100,000. As in, if you can't take into account the payments that were made before the payment claim, you'd have to ignore the payment of the first month's payment claim. So, I mean, I think that's a pretty significant consequence. And I think that's going to mean that we're going to see a lot of development in this area. I think it's a pretty curious result when you've got circumstances where various subsections of Section 13 permit cumulative payment claims. And by that I mean Section 13(6)(b) expressly permits a claimant to include in a payment claim an amount that's been the subject of previous claims. It's been there since pretty much the beginning. So there's no barrier to including old work in a new claim. And there's also, in Section 13, there's no express obligation to note how much, if any, payments have been made previously. So as I say, I think there's going to be some developments in this area. It's a pretty interesting decision, and I think it might have some pretty broad-ranging effects. Okay. The next topic I wanted to deal with was some of the decisions in relation to the DBP Act. Now, I think the big ones that have had all the attention over the years are LULAC and PAFBURN and the like, and I'm not going to... They've been well traversed by a number of our colleagues, and I think there's still some to go in this series. So I think I'm going to have a look at some of the unloved ones, two in particular. And the first one I want to talk about is a case of the owners, Strata Plan 82809 and Omaya Holdings. This was a Justice Stevenson decision from last year. And it's a pretty interesting case for a number of reasons. I'm just going to deal with the DBP stuff today, though. The background facts are pretty simple. It was a residential strata building. The main defect, or the main alleged defect, was about the effective height of the building. So essentially, the building code at the time it was built said that if the building had an effective height of more than 25 metres, you needed sprinklers. And sprinklers were going to cost something like $3 million to install. And so the issue was, the whole week-long case was about how you measure the 25 metres. So although it was one defect, it was expressed through various causes of action. There was also a series of defendants. The cause of action against the third defendant, Omaya Investments, the sole cause of action was breach of the duty said to be owed under the Design and Building Practitioners Act. And it's important to think about the allegations that were pleaded. And in particular, the breach is said to have been that the third defendant ought to have taken precautions to ensure that either the building was designed and constructed to be less than 25 metres, or if it was to be designed to be more than 25 metres, to include additional fire safety measures, and that it breached its duty by failing to ensure that a properly qualified person had made a proper analysis of the effective height and failed to ensure the precautions set out above were addressed. So I think for those of you that have looked at LULAC and their resulting cases, I mean, there's the Stromer decision from Justice Ball, pleading failure to ensure, using those words, are red rags to a bull, particularly Justice Stevenson and Ball. And that's because, as Justice Stevenson noted in the Omaya judgment, the obligation under the DBP Act, the duty is not to ensure anything, it's a duty to take reasonable care. And for that reason, he found that the case against the third defendant in Omaya failed, and that was because the evidence didn't rise any higher than the pleadings. So I think that's a timely reminder, although LULAC's a few years old now, it's a timely reminder that you need to take care in DBP pleadings and evidence on DBP cases, that it can't be framed as failures to achieve particular results. It's got to be about the process. It's got to be what steps a reasonable person in the position of the defendant should have taken that, if they'd taken, would have avoided the defect arising. So most of the time that's going to be in the QA processes. You know, a reasonable person in the builder's position would have carried out an inspection at weekly intervals or whatever intervals, and if they'd carried out that inspection and they'd had a copy of the plans with them, they would have looked at the thing against the plans and seen that something was wrong, and at that point they would have issued corrective action. Although that's a huge amount of detail, that seems to be the level of detail the courts are requiring. Okay, the last case that I want to deal with is a high-powered district court case of Silva, which was, for those playing at home, is owners Strata Plan 80867 and Silva, and it was in July last year. This one's interesting because it, firstly, it involves an individual as a defendant, and that seems to be a controversial area at the moment. Secondly, it highlights some of the tension that seems to exist between these cases where the courts, particularly the Supreme Court, is being very stringent on pleading DBP claims, and notwithstanding that, once you get to judgment, the Supreme Court in particular doesn't seem to have a difficulty in entering judgment, even if the pleadings don't seem to stack up. So just to back up a little bit, Mr. De Silva was a tiler and a waterproofer. Owners Court brought proceedings against him for breach of contract and for breach of the DBPA duty. It was alleged that Mr. De Silva and tradesmen he was supervising removed and replaced tiles on a common balcony terrace for certain residential lots, and the owners claimed that the work done was defective. So it was pleaded that Mr. De Silva was required to perform the construction works in accordance with the building code and the relevant Australian standards. And then it says, but performing the works in accordance with the BCA and the relevant standards would have involved him doing X, Y, Z. So that is, again, the allegations were based on failures to ensure. They didn't use that wording, but that's what they were. Essentially, the obligation, they said, was to produce a defect-free building. Now, that would seem to contravene all the authorities against pleading, that you can't plead failure to ensure, you can't plead results-based breaches. However, notwithstanding that, His Honour, who was District Court Judge War, found that the DBPA duty had been breached. So it's an interesting example of where, notwithstanding questionable pleadings, there has been judgment entered against them. I should say there's a bit of an asterisk on this case. The breach of contract claim, he was also found to have been in breach of contract, and there was an express obligation for him to comply with the BCA and the Australian standards. So I'm not sure the parties spent much time on trying to unpack some of these DBP authorities and circumstances where they were already on the hook for the breach of contract. So, yeah, and as I was just saying, so it's not apparent from at least the written judgment that His Honour was taken to any of the decisions that talked about all the niceties of pleading DBP claims. So we've got to be careful how much you rely on it. I think other than that, that is everything that we'd planned to cover this afternoon. But if anyone has any particular questions, we're more than happy to assist. Hi.
Hi. Let's go back to the SOFA.
Mm-hmm.
15, section 15 in sub 1B.
Mm-hmm.
And when you mentioned it before, that he announced that they had previously included. How does that work in all sorts of progress payments? Usually you would pass well before any claim, but not always, but almost always, the claim would have been made after.
As in next month's claim would have been made before the due date arises for the last one. Yeah, I think there's a rife of there's a lot of practical issues that fall from what they've said. I think it could cause chaos.
So yes, if that's the way they're going to interpret it, then it's.
Well, I think the only benefit you can say now is that at least there's clarity on how the courts are going to approach it. So that's the silver lining. I think it's minimal consolation to people on the receiving end of payment claims, but as I say, I think there could be an appropriate vehicle where that gets brought to the Court of Appeal's attention, because I think it's just going to cause lots of issues. Because if claimants just put in claims of millions of dollars when they've only done $100K of additional work, builders are going to be pretty unhappy pretty quickly, and they're going to be looking for ways around it.
The
Watch
caveat
this
to
one.
that, at least at the Court of Appeal's reasoning, is that if you are encountered with a payment claim of that kind, or you put on a payment schedule.
Yeah, I mean that was very.
So
The Court of Appeal in I think both cases were pretty critical of the respondents for not putting on payment schedules. They weren't receptive to the argument that the whole point Section 15 exists is for parties that didn't put on a payment schedule. We argued that it was Section 15 essentially a legislative backstop, a common sense backstop, that even if you didn't put on a payment schedule, you're nevertheless, a claimant's not entitled to be paid twice. They've got special privileges of the Act. Yes, they should be entitled to it, but you have to take off the payments that they admit they've received. But yes, that was not accepted, and so we are where we are.
Just go back to Strata Schemes Management Act Section 149.
Sure.
Bit of a question about this, but in the opening words of subsection 1, which talks about the tribunal may make an order prescribing a change to a bylaw, and then change to a bylaw is separately defined in the Act as including a repeal as well as a making of the bylaw. But then in subparagraph A, it only refers to the owners' corporation as unreasonably refused to make a common property rights bylaw, which seems to be an intentional difference in language from change, and it doesn't say repeal either, which is referred to in B in the context of owners' consent. So my question is, would you interpret in subparagraph 1A make a common property rights bylaw as extending to repeal? Or if not, is there a hole in the legislation?
I think there's definitely an ambiguity.
yeah, I think there's an ambiguity. It doesn't seem to contemplate a repeal. What this one's really about, as I read it, is all the owners want a certain kind of bylaw. That might be, or some owners want a certain kind of bylaw, which might be to have pets in the property.
This is common property rights bylaw.
Yeah. And they want that pet one, and that's been unreasonably refused. And so it only contemplates, as I say, that the creation as opposed to the repeal, in a way that 1491C contemplates both creation and repeal. So the way I'd interpret it is to say, well, 1A is a kind of forward-looking one, and what 1C is both forward and backward-looking. That's the best.
Say 1C.
So each of these are now or subclauses.
But in circumstances where change is defined separately, I think that does introduce ambiguity.
Yeah, I think that's right. I just wonder how it would arise, because the special feature of common property rights bylaws is that all the relevant impacted owners need to agree to it.
Well, that's subsection 1B.
Well,
That's
in terms of the definition of the common property rights bylaw itself. So that's, I guess, the way in which that arises. You need, by 1431, a common property right law can only be made with written consent of every single owner in which rights are conferred or privileges are conferred. And so that's really where I think 1A operates, because if you're in a situation where you want one specifically for you and you think the owners corporation have unreasonably refused it, then you've got 149 1A enlightened. But as I say, I agree with you, it's ambiguous.
yeah, because what if we've already got one?
Yeah.
Exactly.
Just another example of that, the imperfections of the drafting in that piece of legislation.
It doesn't help, I think, also that a lot of the tribunal decisions aren't reported already on case law, and so you can't find very many examples of factual matrices where these have been considered. And so the ones that get to the Supreme Court are ones like this one, and there's barely any other ones, actually none. We've been up and down all of the cases.
We have, yeah. Okay, anyone else have any? Okay, well, in which case we might leave it there. We might invite you all to join us for some refreshments. Thanks for coming.